Appeals Division 1 is now in session.
Thank you. You may be seated. This is the time set for argument in Huey versus Huey, our case number 1 CACV 200547. Each side will have 20 minutes for argument. Counsel for appellant, you'll be responsible for reserving any time that you'd like. These proceedings are being audio and video recorded. We'd ask that you state your name and who you're representing when you stand up for the first time. We have read the briefs in this matter. We've conferenced this case earlier this morning, and we're looking forward to hearing from you. And with that, counsel, you may begin.
Thank you, Your Honor. May it please the court, my name is David Uffins of the law firm Jayberg & Wilk. I represent appellant father, who is present in the courtroom with us today. This matter stems from 3.5 years of family court litigation and ongoing current litigation as we speak. And I'm sure Your Honors have read the briefing. As you mentioned, there are a myriad of issues that father believes we need to bring to your attention today. I'm not going to touch on all of them. Obviously, I don't think there's enough time to even get through half. So I certainly want to focus on a few things and answer any questions that you have. I think there's an important theme that father and we feel that this trial, the court's decree of dissolution, was contradictory. It was filled with contradictory rulings and findings that are devoid of any evidentiary support, and that demonstrates, in our opinion, clear error and abuse of discretion. Put simply, it's our position that no reasonable evidence to support many of the trial court's findings, and upon review of the trial court's errors and the contradictions, the totality of the decree and the subsequent appeal judgments should be reversed. Perhaps the most concerning example of the trial court's abuse of discretion in this case is the violation of father's right of his due process rights. The trial court demonstrated its inconsistency and contradiction, making findings regarding legal decision-making, relocation, and parenting time that required ascertaining the credibility of the parties, the professionals, the experts, and the lay witnesses that the court could not do in this matter with this specific set of facts, these specific allegations, and these particular facts, through a virtual trial. Now, I'm not by any, sorry.
What platform was used for this trial?
Thank you, Your Honor. This trial was in May of 2020, which was very beginning of the virtual trials through GoToMeeting. And I'm not by any stretch, as I'm sure you're wondering, asking you to set aside over a year's worth of virtual evidentiary hearings. That would certainly not be a reasonable position to take, and that is not one that father is taking here today.
I'm glad to hear you say that.
Thank you, Your Honor.
Help us better understand your position.
Thank you. As we briefed, and as the case law specifically says, the due process requirement is the opportunity to be meaningfully heard for a meaningful amount of time. That did not occur in this specific case. As we briefed, there were, and I believe that Mother corrected in her answering brief, 19 called witnesses. There were 20, I believe, that were proposed to testify. There were over 400 marked exhibits. Admittedly, I believe 77 or so were actually admitted. They're by part of the problem right there, not being able to introduce the proper evidence. This just was not heard appropriately.
But father moved for a continuance. What are you suggesting was the appropriate remedy? How long should the continuance have been? Would it have been appropriate to continue the trial for 2 years?
And no, Your Honor, and that's certainly not our position. Certainly these parties had a right to get divorced, to move forward in their lives, although being in continued ongoing litigation now. But in this specific case, the court had a remedy. The trial court had a remedy available to it. In fact, as we mentioned in the brief, both at an April 27th status conference and a May 14th status conference, the trial court judge specifically spoke to the concerns that he had about going forward with a virtual trial in this case, and had a remedy available to him, which was 2 weeks later, not 2 years, not 6 months, 2 weeks later, June 2nd, 3rd, and 4th, he had an opening for 3 days of availability for in-person trial. He made the offer to both counsel at a status conference saying, we can do this in person. We will follow mask mandates. We will certainly follow social distancing mandates. He expressed consistently in both status conferences, and I'll quote specifically from April 27th, I think this type of trial, we would want to do it in person with the anticipated number of exhibits and just the length of trial being 2 days. Then, 2 weeks later, when we got on our pre-trial conference to talk about whether we could go forward in person or not, the court said specifically, I've been kind of waffling on whether this trial can really be effectively accomplished via the video platform, offered the 3 days of availability in person, and essentially, in my opinion, and I was there and I've read the trial transcripts and I know I've submitted them to you, was making a decision that we are going to go forward this way, let's get everybody on board. Now, there was an objection from Mother's Counsel, and it was a reasonable objection. Certainly, I had COVID in November, my wife had COVID as pregnant in November. It is not something that any of us are looking at as an excuse or anything like that. I know professionally opposing counsel, I certainly would never say that she was making any kind of argument that wasn't appropriate. I certainly believe her concerns. But the court had previously addressed those concerns, that if we were able to go in person, when Mother withdrew her objection to keeping the trial at the same time and date, whether it was in person or virtual, she said, I have a partner that will do the trial if we can go in person. And then we got the ability to go in person. And the court expressed the concerns that we had, about going forward virtually, and over its own objection, essentially overruled itself.
Counsel, at the conclusion of trial, didn't the judge revisit some of those same concerns?
The judge made some comments on the record. I don't believe personally that I took them as any more than comments that we made it through 2 days of a virtual trial. I don't think anybody thought that. We didn't know what would happen, obviously, prior, and certainly there's been a lot of technological advancements since that have shown that virtual trials are possible in some cases. The judge said we got through things maybe without as many slip-ups as he thought, but in my opinion, that wasn't the case. And we put this in the opening brief and in our reply brief as to more specifics, because certainly Mother called out, well, what were the issues? What actually was Father prejudiced with? And I'll tell you what Father was prejudiced with. Father was prejudiced. He lost several minutes of delays on multiple witnesses, including one that I believe was about 15 minutes, and it's quoted in the brief. We lost the ability to get specific evidence in, as noted. There were 400 plus exhibits. Several were foundational exhibits, but only 77 actually got in. And the biggest prejudice of all of this is it wasn't a prejudice to Mother to move the trial 2 weeks, or even to have a partner at her counsel's firm put on the trial who admitted she could do that.
Counsel, at the conclusion of trial, did Father move to extend?
We asked, I believe, at the beginning of trial for additional time on the record.
My question was, at the conclusion of trial, did Father make a motion to extend?
We did not, Your Honor. No, we did not. Although I think we brought this up, and I felt like at that point probably beating a dead horse before the judge, but we had asked both on the status conferences on April 27th, on May 14th, and then based on the court's ruling, asked the court, can we submit a formal motion? And he said, I understand your arguments, they're documented on the record, but if you'd like to object and move a motion to continue, and we did that as well to document it.
But after the fact, was there any suggestion that as to this witness or these documents, there was a problem that we would like to have addressed? Was anything done after?
Not on the day of trial. Certainly we moved after the decree was entered on specific findings, because it came to our attention that, in our opinion, Father's opinion, that the contradictory findings made, in my opinion, I don't know how they could have been made other than perhaps some issues with the trial being virtual, because there are several instances of just direct contrary findings to themselves. I mean, even the court made findings that are contradictory to each other. But no, to answer your question, Your Honor, there wasn't a direct response after the trial as far as a motion to extend or to clarify a witness's testimony or anything like that.
Could you explain which rulings you think were contradictory? Is there beyond the ability to care for children, ability to work? Is there Are there other contradictory, what other contradictory rulings are you suggesting are out there?
Thank you, Your Honor. And there are several, and I have some briefly to go through, but I would point to the briefing for the majority of them. The first, and I think this is important because it goes to the question of the reliability of the witnesses through the virtual platform, and that is the finding or lack thereof of a significant history of domestic violence under 40303 that would preclude father from legal decision-making. I don't believe that the court made a specific finding of a significant history of domestic violence or a significant act of domestic violence. The court mentions domestic violence and abuse that warrants further discussion, and then goes through in the decree, briefly touches on there are allegations that were made that then were also found to be falsely reported or unreliably reported by the children. And the court actually found that those were unreliable, that the children were unreliable reporters regarding allegations of abuse, yet appears to have hung its hat on the domestic violence or abuse finding in order to preclude father from an award of joint legal decision making. I would believe that to be contradictory because there's not a specific finding when it's contradictory in its findings elsewhere. Another example would be specifically about the spousal maintenance award that's indefinite, and the award of parenting time and relocation for mother. The court is essentially saying, the trial court is essentially saying, mother is a fit parent to be able to parent two children, one of which has been diagnosed as autistic, the other of which has made significant false allegations to DCS, police, the court itself, through mother and through therapists. Can parent both of these children full-time, move them across the country away from their father without any support from father, who, by the way, was also found to be fit for unsupervised parenting time, no restrictions on his parenting time going forward as of the date of the decree, yet then says mom can't work, not because she's taking care of the kids. That was actually never presented as a fact from mother, nor was it something relied on by the court, only because of her mental health, that she is so mentally unhealthy that she cannot sustain the duties of a job. She had an expert, her psychiatrist, treating psychiatrist from Arizona, to testify to she cannot do the roles of a job.
What if it had been an award of 1 year of spousal maintenance? Would you still be suggesting that it's a contradictory award? Is any amount of spousal maintenance not warranted?
No, not at all. In fact, I think while we believe mother was perhaps over-asserting her allegations about her mental health being a stumbling block to finding future career employment, in this case, not at all. If spousal maintenance were awarded for a set fixed term, as this court has found in several cases, to say that the goal of spousal maintenance is basically to rehabilitate and get that party back into the workforce, had there been a 1 year, 2 year, some fixed income, a fixed amount of maintenance, certainly that wouldn't also be contradictory to the finding that she simply could never work. Because that, and I guess I stepped into it a little bit there, I don't think the court actually found that mother can never work. In fact, the court made some contradictory findings in that aspect too, saying she's improving when it comes to the children. Her mental health episodes, her suicide ideation, all of the issues that had gone on had diminished to the point where she can care for the children, but not to the point where she could carry out a simple job function.
But if you're acknowledging that the court it wouldn't necessarily be contradictory to say she needs spousal maintenance, but she's capable of taking care of the children, is there a hard and fast line that we can say? Doesn't that turn it then into a very deferential review on our part to say, if there's no prohibition on indefinite spousal maintenance, how do we draw a different line and say, oh, we think it should have been 5 years or 4 years or 3 years? That seems to be a difficult inquiry for us on appeal.
I certainly agree, and Your Honors certainly have the The position is to review, obviously, whether there are evidentiary supported facts that the trial court could have reasonably relied on, not to put yourself in the trial court shoes as of that day. In this case, specifically with an indefinite award, I believe it is contradictory, and it's because of the indefinite award. I don't know that I could make that argument if the court had made a 5-year spousal maintenance award, because it's definitive, and it could be used to say we're going to progress mother to be back into the workplace, or at least give her a timeline to establish whether or not she could, in fact, increase her employment. In this specific case, in Hughes and Rainwater, the specific requirements of the trial court in analyzing indefinite spousal maintenance is whether the court could find that she could not, in the foreseeable future, be working again. That is contradictory to being able to take care of the children, to find that you can basically never
Counsel,
work.
there's very specific testimony from mother's expert that says that the stresses that are imposed by parenting are not the stresses imposed by working. Where in this record can you point me to the other evidence on the other side, and given the standard of review we have, what are we to make of that?
I guess from my perspective, I believe the record does have citations to the position that, and I believe it was on cross, that mother can, or is not saying, or I think actually it was my cross of the direct expert saying that it's not saying she can never work again. And the trial court found that it's not saying she can never work again. I think it's, and this might just be me personally and father's position, that it's not a reasonable fact to find that parenting stresses are that much easier or different than simple job functions. And we offered some examples in the briefing, but certainly by no means are meant to limiting mother could be an aide at a school or could caregive or anything like that. To say that child rearing is easier than performing job functions, I think is
or rearing
inaccurate.
your own children versus providing services for other people's children. Is that what you're saying? That it's always equivalent?
I don't believe it's always equivalent, Your Honor. I think that there's just a disparity a contradiction between saying that you are able to raise an autistic child and a child that's gone through now several years of making false allegations and unreliable reporting to agencies, to the police, to therapists. You're able to raise those two children without any help from the other spouse or the other party, the father in this case, move them across the country, but you can't hold a simple job in some capacity.
But you said 1 or 2 years of spousal maintenance wouldn't be unreasonable. It wouldn't be contradictory. If that's not contradictory, again, I just come back to the point you're just asking us to draw a different line.
And I believe that it's because that'd be rehabilitative, Your Honor. And also, it's allowing mother to get to a point of achieving financial independence, which is what the case law provides spousal maintenance purposes for, not to provide for mother forever. And I think one of the distinctions that we brought up in this case as well is now we're giving mother permission to leave with the children, go across the country with the children, and by the way, she also, and I think this is in the record, shielded her mental health records for over a year during litigation, requiring motions to compel and other issues. We're asking father to be the party to bear the burden to modify an indefinite award. That can't be just or equitable, and I don't believe that the court has the authority to say, you're in the position to say when mother can or cannot work again when she's left across the country. I'd like to reserve a couple minutes if I can, unless you have a question, Your Honor. Thank you.
Good morning. Angela Hallier on behalf of Ann Huey, the appellee. Oh, don't touch, it says. There's no doubt the standard is an abuse of discretion standard, which occurs when the record is devoid of competent evidence to support the decision of the trial court. Here, the evidence is clear. The record is replete with evidence that supported the court's use of its discretion to make all the awards in this case. I will just respond to a few of Mr. Uffen's points, and then I hope you will ask me questions about anything you want. With regard to the indefinite award of spousal maintenance, first of all, There was nothing in the record at all that indicated wife could work now. Nothing. The testimony was from her treating psychiatrist, who said right now she could not. The court properly exercised its discretion on the record to award her indefinite maintenance. The argument seems to be more one of where the burden was placed, and as Rainwater says, the court has the discretion to place the burden where it wishes.
But I think our case law has made clear that the award of spousal maintenance is intended to help someone get back on their feet. It isn't, this seems to go against that general notion that we see awards where someone needs some time to finish their education, to become more employable. This seems a little different, where mother has had a career and is well educated. What's the justification for an indefinite? I mean,
there was no evidence when or if she could get employment, as stated by the court in its decree.
But doesn't that put the burden on father to come forward with how can he ever come in and show that she's now capable of working? Wouldn't it make more sense to say there's a 5-year award and then come in and explain why that needs to be extended?
Sense, I don't know, but the use of the court's discretion was proper, we think. It was the court's discretion to say, there's no evidence in this record before me whatsoever that tells me when and if she can work. Father put on absolutely no such evidence. So the evidence was, we don't know if she can ever work again. That was it. There was no other evidence. And the cases allow the burden to be on father's plate. Father produced no evidence of a potential
I
work
agree
point.
that not capable of working right now. But I'm asking, do we leave that burden on father just indefinitely? 10 years down the road, it's still his burden. It seems like an odd way to make that assessment down the road.
Well, on this record, yes, the court did it correctly, in our opinion, because mother has no possibilities of employment at this time. So the court would have had to guess on this record that there was a point at which she could. So,
Counsel, isn't that sort of a component, though, of the spousal maintenance work always? I mean, if you had the ability to work day one, current day, there's a pretty healthy argument if there's at least equal earnings, the spousal maintenance may not be appropriate. So, I mean, you've said several times no evidence that she could work at the time of the trial. I think there are a lot of trials like that that don't end up with sort of an indeterminate spousal maintenance.
it's okay. I was getting help from my friend over here. Well, first of all, that doesn't mean there's an abuse. But how does the court determine then if there's no evidence that she can ever work? There was no evidence here she could work at any point in the future. So the placement of the burden was appropriate on father.
There is some evidence that she's able to function and is well educated. And why isn't that at least some evidence that she would be able, as counsel has suggested, to work doing something with children or something? It seems odd to say that there's no evidence that she can do anything in an employment setting.
With all due respect, that seems very speculative on this record. Where was the court going to get that information? The testimony was she may be able to work again someday. The testimony was she had severe depression and anxiety that became disabilitating during the marriage. So how does the court just decide I'm going to pick a year or 2 years or 3 years when the evidence before it is that there is no certainty at all she can ever work?
I guess it's just a little bit troubling. If the court had awarded 1 year of spousal maintenance, would you have an argument on appeal?
She could come back and keep going and going and going and going.
Right.
Just like he has the right to come back.
Right, but if it says an indefinite award, so I guess your point is then that father can come in after 2 years and make an argument that I'm not sure exactly what position he'll be in to know what her mental health is like. It just seems odd to put the burden that way, but I think I understand your point.
I just don't think it's abuse of discretion, and it's allowed under the law. And again, on this particular record, there's nothing a judge can just pick from in the air. Again, it's discretionary. You're just going to pick a year because why?
Well, but if it truly is discretionary, that's at times what finders of fact have to do. Pick a number from the
But he did. He determined that the burden should be on father, and he determined there was no evidence before him to tell him at any near point in the future. Nothing. It could be 1, 2, 3 years. Hypothetically, had there been an expert on their side that said, hey, I believe, based on her medical history, 3 years away from this household, away from the divorce, that might be the point, I would think the court would have something, but there was nothing. And the truth is she can't work, and the truth is there's no evidence she could work.
To follow up on Judge Catani's question, what, say 4 years down the road, what could father show that would change that, hypothetically? Because clearly, we're first of all looking in the future, and secondly, talking about something that's not on record here. It puts the burden on him. What can he show?
Right, treatment records.
How would he get those?
He can subpoena them, he can request them, because...
And there'd be no objection under HIPAA or otherwise?
Well, there's an ongoing spousal maintenance issue.
I
mean, the court can draw a negative inference, obviously, because if he came back in and tried to modify and she refused to give her records, then there's a negative inference for the court. Counsel can be, it happens often. This isn't just related to indefinite maintenance. It happens with 1 year or 2 years or 3 years.
I understand, but at least from the published cases, indefinite spousal maintenance is an exception now.
Correct. And it fit the facts of this case. She was just coming out of horrific, and the record reflects, horrific mental issues, psychiatric issues, some of which had been misdiagnosed. It was only after leaving father that she started to get relief. She had had in-treatment before.
But isn't that the point of the spousal maintenance, to allow someone to get on their feet? But that's the point of a separation. Now, presumably that stress is going to be mitigated by being away. If that's the cause of the stress, it still seems odd to suggest that we don't anticipate anything to change in the future, even though that you made that separation.
As we sit here today, is this, maybe if you had been the trial judge, you would have thought that, but there's no evidence she can work now or in the future at all. There was no evidence she could ever go back to the level of functioning she had before.
So you wouldn't consider evidence, competent evidence that she's a capable parent, evidence that she has a college degree? That is some evidence. You might discount it, but there is some evidence from which a fact finder could conclude that she will be capable of working at some point in the future. Would you agree with that?
I'm not sure I do in this case with these facts because of the severity of her issues. I believe that if the court would have imputed minimum wage to her, we still would have had the same outcome, because any supposition would have had to be at a minimum level. The court could not have found she could make $50,000 a year or $100,000 a year at any time in the future. So it would have been a minimum wage, and then we could have still had indefinite.
So let me ask you to, among other things, address a lot of the issues are on abuse of discretion standard. The due process issue, though, strikes me as more an issue of law. I would like to hear from you on that point.
Okay. Well, it is an issue of law that occurred in the middle of a pandemic, so it's a little special. First of all, the court could, in this case, see everyone. Everyone has a right to be seen and heard. The suggestion is that if we would have been in person with masks on our face, the credibility reading would have been better. That can't be the case. There were stay-at-home orders. Judge Cohen had said everything will be handled virtually. The record shows no issues with the technology. In fact, the specifics stated by Mr. Uffins in his reply brief are like 1 page of a transcript where someone's trying to log on. I think the most pages in the entire transcript where someone had trouble logging on was 5 or 6 pages. The court said it could see everybody, it could hear everybody. there was no denial, and if you follow the logical trail, there wouldn't have been a trial yet, because we're not back to in-person trials. So there were no logistical concerns that came to light. It seems that the argument really is about time. I didn't have enough time, but the record doesn't reflect an absence of time, and it wasn't complained about. What it reflects is it was virtual, but everyone could see everyone, and it worked very well.
Counsel, what of Mr. Uffin's argument that that was not meaningful?
Well,
So
I don't
saying-
even,
His argument is, well, yeah, we were able to show up and we were able to do this and that, but it wasn't meaningful because of the volume of other things that I wanted to present. What do you make of that argument?
I make that not a good argument. I mean, it's nothing was lacking virtually that would have been lacked had we been in a courtroom. The exhibits were still there. Everyone participating had paper exhibits in front of them at each location they were at. The judge had their exhibits there. The judge could see everybody. Everybody could be cross-examined. It literally was no different than an in-person trial, except for an in-person trial at that time would have required masks. And other than that, it went off without a hitch. And there, again, was no objection during the trial that something was delayed. There was no request for additional time because it went off without a hitch, as the judge said on the record twice. And I guess I can't understand how being 20 feet from a human being and seeing their face in a mask would have been better than a screen where everyone can see everyone's face at all times and hear them. And some of the due process cases from criminal, allow that video is fine. Some of the federal cases, which I don't have in front of me to cite to you right this minute. But the right to confrontation of your accuser has been held in multiple cases to be met by video.
Counsel, I don't think there's a claim that the confrontation clause applies in the case.
No. Drawing an analogy.
I understand. Appreciate it.
Is there specific other areas before I continue on that you would like to hear about so I don't waste my time? Or yours? I would like to address then, and I think everything else that is complained of by father has support in the record. The relocation, the sole legal, I do just want to comment that you don't have to find significant domestic violence occurred to determine it's in the best interest of a child that one parent have sole legal decision making. You don't have to find that significant domestic violence occurred to allow a parent to move. The standard is the best interest of the children, and here the record was replete with reasons that the court decided mother should have sole legal decision making and mother should relocate.
Counsel, was there any evidence, or can you point me to where in the record where it might discuss father's engagement or level of engagement with the children, and if it would be substantially impacted by relocation?
Yeah, I can't tell you what pages exactly in the record, but I can tell you this, that there was evidence he minimally saw the children, in part by choice, for the 2 years prior to the trial. There was substantial evidence that he had failed to participate with the children when requested by their therapist. He had failed to get the recommended training to work with his son on autism. He had failed to contact their schools. He didn't know what his son's IEP was. And back to, was your about legal decision-making or parenting time?
I was talking about the effect of engagement, or the level of engagement that relocation has worked upon father.
Right. So the court found, and the evidence reflected, he would actually have more time with the children when they moved. That his relationship with them was so attenuated that his interest in them was very minimal. He, on one occasion, left for 3 months and admitted on his cross-examination he didn't think about what it would be like for his kids not to see him for 3 months. So his relationship, and there was evidence of domestic violence during the marriage that the kids witnessed. So all of that went into the court's decision to give sole legal decision-making to my client and to allow the relocation. Mother testified for pages and pages and pages on her direct about the benefit to the children of moving. Dr. Lavitt reviewed 1,400 pages of documents and did a lengthy report summarizing the facts of the case, and then opining as to how he thought those impacted the statutory factors. If there's nothing else then, and thank you for your time, I would like to address that this appeal has had a financially devastating effect on my client. She hasn't received the money she was awarded from the court. She is going into her retirement, and we feel that all, if not almost all, of the issues raised by father are not for this court. The arguments appear like they're for the trial court, not for the Court of Appeals. The arguments in the briefs, which wife had to obtain extra counsel for and respond to, are as if the arguments are to the trial court. This has been devastating for her, and it's in the record that he said he'd ruin her if she divorced him. And this appellate action has really taken its toll on her financially, and we think it's very important that if there's a case ever that called for an award of fees, it's this one. These were all discretionary decisions, and they were all supported by the record. There's no abuse of discretion, and we sincerely ask you consider awarding my client fees on appeal. Thank you.
Thank you, Your Honors. And I just want to briefly address a couple quick things that counsel made comments about. The first being about sole legal decision-making, because I think it's really important that we address the specifics that the court missed in its contradictions. The court specifically found here something that the Arizona courts and the legislature have overturned previously regarding parenting time in its decision-making order, and that is that the former best interest factor that the legislature removed in 2012 and was cited by this court in Barron, of a factor that mother being potentially the primary parent in the past would continue for parenting time. The court, in this case, the trial court judge, made a finding the same thing with decision making, that mom had somehow been the default decision maker during the marriage, and held that, it appears to me, against father in its award of sole legal decision making. That is something that we believe is contradictory to the law and needs to be struck, and if anything else would allow the court on remand to go back and make proper findings about decision making. The other thing that the comment from counsel regarding, I think it was in the question, Your Honor, to your question, the response in your question to how relocation has impacted father. Obviously, the court didn't allow the mother to relocate until after the decree, so the time on the record is not reflected for what the findings are not there as to what impact it would really have on father. We produced evidence from professionals. I believe both therapeutic interventionists testified that relocation would be difficult on reunification with the children. And in fact, it has been, that there were supervisors, both court-appointed, and one specifically that also serves as a therapeutic interventionist regularly, that said that this is going to be very difficult on a relocation is going to be difficult on any kind of meaningful parenting time to father. And essentially, that's all that happened. And my point about the virtual trial issue is, how do you give the judge the ability to ascertain this evidence when it appears he clearly missed it in this case? He knew that there were going to be issues, he raised those issues, and he said, I want to do this the right way, and then didn't. And that's why we believe that the court should reverse and remand all of the decisions or the issues that were outlined in our briefing. Thank you.
Thank you for your argument. We will take this matter under advisement and issue a decision in due course. With that, we're adjourned.